Lordship, I am respondent number 4 against item number 1 and 2. Senior to my, sorry to inform you that my senior counsel, Mr. R. Islam, had a stroke in the last midnight. His wife has informed me that she's taking her to Guwahati Hospital. So the death may be quick in the last of this month.
2nd December. 2nd December. Item 1 and 2. As it is informed in the court that the counsel representing respondent number 4. Suffered ill health and is under medical treatment. The matter stands referred to be listed on 2nd of December. Mr. P.K. Roy Chaudhary, counsel for the petitioner, is also present.
Lordship, court number 15, item number 11. I'm praying for fixing a date, any date, Lordship.
No, this is only for mentioning urgent matters, not for adjournment.
No, in fact, Lordship, this matter was yesterday mentioned before this honorable court. Lordship directed for listing today. But today, court number 15 is not sitting.
So I don't think the briefs are available here. Huh? They're not here.
So I'm praying just for fixing a date, Lord. Nothing.
So where will I dictate the order? The file is not here.
It's
Even if I pass an order, that order will have to be recorded in the order sheet. It is only for mentioning some urgent matters you want to do, which are placed before that court.
I understand, Lordship. I will mention this matter again, Lordship, on 7 then. Problem.
May
Yes.
please, my lords. May I pray for the listing of a matter? I had filed a writ petition on 2710, my lord. It's not yet listed. I pray on 7th, my lord, if it pleases. I'm so obliged.
May it please your lordship, item of the deferred list, item code number 15, is item number 8 and 9, my lord. My lord, what has happened, the persons are being suspended and the 90 days period has been over. On the last occasion, today was supposed to they bring in instruction and they already started a DP proceeding. There is no review of the order. My lord, that was the urgency in this petition, my lord.
You want the matter to be taken up today?
My lord, if my lord permits, or my lord may take it on 6th. 6th. I understand, my
Don't make a
lord.
mention
Yes.
unless you want to do the matter today.
My lord, if allows, my lord may take it up today, my lord. 8 and 9.
Second up.
8 and 9.
May I please, I beg to mention for listing, my motion, my lord.
You have to inform the other side. Mr. Counsel, you have to inform the other side.
My lord.
Only in the presence of both counsels will take up the
Yes.
matter.
I am paying for listing, my lord, motion, my lord. On Friday, my lord.
Motion matter, why?
No suspension case, my lord.
Fresh matter, old
Yes,
matter?
fresh.
Fresh matter.
Yes, my lord. Friday.
Friday.
Please, your lordship. Lordship, I beg to mention for listing of a writ petition, lordship, which relates to pensionary benefits of a person who retired long 2020 matter, lordship. Any date complete?
2020.
Yes, lordship.
17th?
Yes, lordship.
May I please?
Highly
lordship?
obliged.
Yes.
Item number 28, my lord, court number 15, lordship, this matter fixed for hearing for today, my lord. But the urgency is there, my lord, the matter may be taken on Thursday, my lord.
You don't read the notices. Notices are for mentioning if you want to do the matter today. If you don't want to do it today, don't make a mention. Yes.
So the mention for listing the matter related to promotion matter, Lordship, promotion service. And people are
17
going to retire-
November.
Lordship?
17 November.
I have a similar prayer, Lordship, because DPC is going to be conducted without
17.
consideration. 17, Lordship.
May I please, your lordship.
21 casually paid laborers. My lord, they are working in GRAF, your lordship, under Border or Roads Organization.
Yes.
So for 20 to 40 years, your lordship, they are working. The date of their engagement, I have also stated in annexure in the petition itself in a tabular form, page 80, Your Lordship.
No, this is about, you are referring to some.
Like Jammu and
judgments of-
Kashmir judgment.
Who's for the other side? CGC,
CGC.
CGC.
And Jammu, because Your Lordship, Jammu and Kashmir has rejected the prayer of regularization, but said that they should be given if someone appointed prior to 1993 on the date of scheme issued in the year 1993 for grant of temporary status and regularization, then that should be given. Lordship will look into the page 80, Your Lordship, the tabular form, I have given the date of engagement. My two alternative pairs are there, my lord. One set of employees, those who have been appointed on the day of 1993 or prior to that, they should be given the temporary status, and rest should be given minimum of the pay scale following the state of Punjab versus Jagdish.
Somebody placed a judgment of this court, coordinate bench, Vartak Labor Union.
Yes.
What
It
is
is there.
this?
It is there. Because thereafter that judgment was passed. Yes, that is there, my lord. I have placed it. Page 2, 59. Page 59, your lord.
Just 1 minute. Yes. Yes.
Although the judgment of the Guwahati High Court was reversed by the Honorable Supreme Court, but with certain observation in para 22, your lordship, the judgment started from page 59. And para 22, page 62, your lordship. In the right hand side, in the bottom, para 22, your lordship. Some observation was made by the Supreme Court.
62.
Judgment started from page 59, annexure 5, and relevant para
No.
22 in page 62.
No. There is another judgment here by a coordinate bench, WPC 6609. Somebody has placed it. Huh?
We have placed it.
You are not aware of the judgment.
No, we are regulation, we are not seeking, my lord. We are not praying for regulation. Our limited prayer is in the light of the Jammu and Kashmir judgment.
Have you seen this judgment or not?
Judgment has not been given.
WPC 6609.
That judgment has not been given to me, my lord.
Why don't you serve them a copy?
On last occasion, also, we have served this copy to the Honorable Court Lordship. And
I
at the
know.
time, Lordship, there was a prayer from the other side, Lordship, that they will take instruction regarding that issue also. And regarding Lordship, Jammu Kashmir and High Court, what is the present status, that will also enlighten the court. That was the submission of the Council for the petition, Lordship.
No, copy of the was.
Copy, Lordship, this is High Court, Lordship.
Just a minute. And in the Guwahati High Court judgment, my lord, Jammu Kashmir judgment, this Guwahati High Court judgment also referred. It was reversed by the Supreme Court earlier. Reversed by the Supreme Court. And therefore, prayer for regulation
there are
was.
two Guwahati High Court judgments. One is at
Yes.
page 59, against which an appeal was filed.
My lord.
Right?
My lord.
And subsequently, there is another one.
Now my friend has said,
Ah.
yes, my lord.
Have you seen that?
So that I have not seen.
What is your prayer here?
Here, my lord, my prayer is very limited. Lordship will find.
Hmm.
Page, page 30 it is started. Relevant page 31, your lordship. I'm reading it. A writ of mandamus or certiorari or any other appropriate writ or orders and direction should not be issued directing and or commanding respondent to grant of temporary status and any other benefit in terms of casual laborers grant of temporary status regulation scheme 1993 to the petitioners who were in employment as on 1993 and to pay the other petitioners. There are two sets of petitioners here, my lord. One, some of the petitioners were engaged prior to 1993.
This will require some extensive hearing. We'll not be able to
The-
finish it in admission hearing. It is not possible. We'll have to go for a regular hearing.
Can I show only one thing, my lord?
Yes.
The Jammu Kashmir judgment and their statement regarding same union, same, my lord, same casual laborers. They approved the Jammu
Yes, do
Kashmir judgment.
you agree with this judgment of the Jammu Kashmir High Court?
That I have submitted, Lordship, regarding Jammu Kashmir, there has been challenge in the division bench of the Jammu and Kashmir, Lordship.
Oh, that
And
is,
that, and there has
SLP
been
has
state,
been
Lordship.
dismissed.
There has been state also, Lordship.
Huh?
And that judgment is stayed before by the Honorable Division Bench of Jammu Kashmir, Lordship. And the case is fixed on 18/12/2025, Lordship.
You said it has gone to the Supreme Court?
My lord. No, Supreme Court, my lord. No, earlier judgment went to Supreme Court. Earlier judgment of the Jammu
Which
it is
judgment you are
reflected.
relying? Which judgment are you relying?
Jammu Kashmir judgment.
Which judgment? What is the name and the case number? What is the citation of that case?
Page 84, your lord.
Hmm.
85, your lordship, annexure 9. And lordship relevant para 24, page 101, your lordship. Or 25. Same casually paid laborers. Para 25, your lordship. 101, please. May I read it, ma'am?
When were you all employed? When were you in employment?
Page 8, I have given the. Page 8, my lord, the dates of engagement. Now it is 30 to 40 years they are serving, my lord.
The Jammu Kashmir High Court allowed the regularization under the 93 scheme.
Claim of the member president is rejected, my lord. Para 25 for regularization.
Number 2,
Number 2, only the benefit, my lord, of temporary status to be given as per scheme,
which scheme?
1993 scheme.
When were you appointed?
My lord, some of them were before 90. Their dates are given in the page para
So
3.
only
page eight.
those persons who were appointed before 93 will be allowed. How can the others be? Others can-
And my second prayer is, my lord,
Hmm.
to grant minimum of the pay wages. That has been also, my lord, para page 103.
No, not like this. Heard counsel for parties. Issue rule. Matter be listed for hearing on 8th of December.
Obliged.
Hear it on 8th of December.
Obliged.
May I please?
Yes.
This matter is regarding minimum pay scale, my lord. Uh, My case is covered by judgment of this.
I can't hear you. Can you be a little louder?
This,
Yes.
this matter is regarding my lord, the minimum pay scale, my lord.
Huh.
Petitioner was appointed in the year 1998, my lord, and he received salary till March 2011, my lord. Thereafter, my lord, the treasury officer stopped paying salary, my lord. You- Then, my lord, the petitioner approached before the treasury officer. Treasury officer, my lord, told them the finance approval of the finance department is required, my lord. Thereafter, my lord, page 21, my lord. Child Development Project Officer, my lord, submitted status report of the petitioner, my lord. Page 21, my lord. Relevant person is page 22. My name is appeared in serial number 1, my lord. Enamuddin Bulbuya, grade 4 employee, my lord. Remarks drawn up to February 2011, my lord.
Your name was earlier not sent.
Lordship?
Have you seen the affidavit filed by the department?
Yes, my lord.
Come to page number 56. Para 4, page 56.
Yes, my lord. Finance, my lord, rejected my case, my lord.
So,
But similarly, my lord, similarly employed, my lord, Habib Sajjadur Rahman was allowed, my lord, they given the minimum pay scale, my lord.
what
That is
basis
not-
you say he is a similarly situated person?
Yes, my lord. Page, my lord, page 22, my lord, Sajjadur Rahman, Madar Bhaiya, my lord. He was given, my lord, minimum pay scale, my lord, annexure 12 may be seen, my lord.
Where is his name in the list which was forwarded by the department?
List is, my lord, page 46, my lord. Relevant 49, my lord. My name is, my lord, serial number 9, my lord. Enamuddin Bulbuya, my lord. And Sajjadur Rahman is, my lord,
46 is an affidavit.
Lordship, from affidavit, I am saying, my lord. Page number 46, my lord. Running page number.
Yes.
Relevant portion is, my lord, 49, my lord, page number. In serial number 9, my lord, petitioner's name is appeared, my lord. And petitioner number 1's name is appeared in serial number 1. Sajjadur Rahman Majar Badbuya is Lordship, petitioner serial number 42, my lord. Page 50, my lord.
Where do you say that he has been regularized? Which order?
Lordship, in my writ petition, my lord, I have annexed that speaking order, my lord. Page 12, my lord, page 44, my lord, annexure 12. Before, my lord, the finance department issued this notification, my lord, our proposal also send, my lord, annexure 6, my lord, page 24, my lord. 128, 2021, my lord.
But where is the order granting him that benefit?
Lordship, he is already getting the salary, my lord. The same ICDS project, my lord, same.
But there must be an order.
Yes, my lord.
Where is that order?
I will produce, my lord, if Lordship grant
We are not preventing you. You produce the order.
at 2 p.m. my
Page
lord.
number 44, 45 is not the order,
Lordship, at 2,
not 2 p.m. You bring it by way of an affidavit, whatever documents you want to place.
most of it.
Both the matters are similar.
Yes, my lord.
Heard counsel for parties. List again after 2 weeks, enabling the counsel for the petitioner to bring on record additional documents as prayed for by filing necessary affidavit. Yes,
Most of it.
MS H. Borua and D. Bora appears for finance and state. No. Yes.
So for Lordship, the DPC minors Lordship, here in this case Lordship, it was not traceable Lordship or the original.
Not traceable.
code, Not traceable, but at the same time, Lordship, the soft copy we downloaded from the computer, all the documents are in the.
You have some
computer.
printouts? You've taken printouts?
Lordship,
Oh, wait, what do you say that the minutes are not available, but it is available in the computer? What is this?
Lordship, it is a soft copy Lordship.
Ah,
Soft copy is there Lordship. But the hard copy after signing Lordship, the hard copy is not available. It was not traceable. Lordship.
let us see. What is the name of the petitioner?
Lordship, Pranab Kumar Das, Lordship.
His name is not there.
Lordship, his name is not there, but regarding regarding the that Lordship resolution 3 stated that the following officers under grade E are hereby selected for promotion to the officer grade D, giving effect to their seniority as on 03/09/2020.
You are
The-
reading from which page?
It is Lordship, the soft copy, page number 4, Lordship. Resolution 3.
They are kept under seal cover. For what purpose?
Lordship, Lordship, one, the chocos was issued against him at that time. But articles of service were not furnished. That is admitted fact.
But there must be something mentioned in the agenda. These are the proceedings. The board level committee must be apprised that there is a proceeding pending against the person, which calls for putting it under seal cover.
Lordship.
There is no mention here.
seal cover is mentioned, Lordship, but the Lordship, Lordship, it was there in page number 3, Lordship. It is there, Lordship, in page number 3. Page number 3, Lordship, after it is,
Serial number 20,
no, Lordship.
serial number 2. Which one?
No, Lordship, the paragraphs, Lordship, it is after completion of the list, Lordship, the table, Lordship, after that, there's a paragraph 2. The managing director informed the committee that there is a departmental proceeding pending against Dipankar Das. The managing director has also informed that the committee that it is Dipankar. Further, Lordship, it is paragraph number 3. The managing director further informed that the Pranab Kumar Das ABM presently attested with Nalbari branch committed a major irregularities in respect of the housing building loan availed by him while serving at Haflong branch, and the bank is completing disciplinary action against him, Lordship.
Contemplating.
Yes, contemplating. This is mentioned. And due to this reason, the two persons kept under seal cover, Lordship.
What seal cover? How can it be seal cover? DP contemplated, serial number 4. Is there anything under the rules, service rules?
We have our service rule, Lordship.
Where are they?
Regarding seal cover, Lordship, it is not. Regarding Lordship seal cover, there is no mention in our rules, Lordship, but it follows as per the existing laws, Lordship. Regarding seal cover, Lordship, seal cover.
There is no
procedure.
specific rule.
Yes, Lordship. We have no specific rules.
What do you say about Janaki Raman?
Yes, Janaki Raman, Lordship, it is clear that it is very clear that after charges was famed, it is called as departmental proceeding. Pendency of the departmental proceeding is called after faming the charge, Lordship. It is in neither in criminal case, charge fame, and in DP also, the domestic. It is departmental proceeding also after furnishing the charge memo, Lordship. This article of charges.
So what is to be done here?
Lordship, here, Lordship, from the record it appeared that the charge was famed after the DP, Lordship, not before the DP.
Who is entitled?
Lordship, he is entitled, Lordship.
Yes, Mr. Chaudhary, anything more?
That it is clear, an admitted position, my lord. There was no pending proceeding. While the DPC considered, my lord, for promotion of the employees, my lord. And my name in the seniority list, my lord, appears in serial number 5, annex 3, my lord. Page 25. And number 6, my lord, Biplab Datta Surri, he has been promoted, my lord,
No, but
I
Lordship,
was not promoted.
entire batch was promoted, Lordship. Entire batch was promoted.
Except him.
Yes.
Except these two, Lordship, Dipankar and this one, Pranab Das. due to, as per the DPC, due to the pendency of departmental proceedings.
So who is your immediate, who was the immediate junior?
Biplab Datta Chaudhary, that's for number 10, my lord. His name in the seniority list in serial number 6, my lord.
You are still in service or superintendent?
Yes.
Still in service.
Service.
As per date of joining বনাইছে না ওটা? Date of joining. No, Lordship, here in my list, Lordship, Biplab Datta Chaudhary, he was joined on 16/02/2011, Lordship. But the petitioner Pranab Kumar Das was joined on 01/08/2011, Lordship. It is in the minutes, Lordship. Lordship, it is Lordship, there is no, they were not categorized the seniority, Lordship. Entire batch were promoted, Lordship. This is the aspect.
My lord, only I was, no, my case was not considered, the others were considered.
Yes.
So I am entitled to promotion from the date of their appointment.
That is what we asked you. You mentioned the private respondent, but
All private respondents have been made.
you show him that list.
Lordship, this is the, yes.
This is the minutes. The minutes reflect second page. Serial number 4 is your name.
Yes.
Your joining date.
SC candidate. my lord.
Your date of joining is shown as 1/8/2011. The other serial number 5 onwards is shown to be earlier.
But my lord, the seniority list prepared, my lord. At page 25, my name appears, my lord, in the seniority list, serial number 5, my lord.
Your name appears in?
Serial number 5, my lord, at page 25.
That is what we are saying. Page 5 in the writ petition.
In the petition.
Page number?
Page number 25, in Annexure 3. It is their seniority list, my lord, on the basis of which my lord, the promotion was granted.
Page 25, that is also this also reflects the same thing.
Yes.
That is
Date is 1/8/2011.
No, but this seniority was determined as per the court order according to the date of birth, lordship. It was according to the date of birth. It means not the positional seniority, it is a seniority, lordship.
Date of birth from 17 to
Yes,
ATC.
it is as per the age seniority, lordship. It is not the positional seniority.
Red Heart, Mr. D. Chaudhary, learned counsel for the petitioner, as well as Mr. J.K. Goswami, learned counsel appearing, government advocate appearing for the, sorry, not government advocate, standing counsel appearing for the respondent Assam Cooperative Apex Bank,
4 to 14.
representing respondent 1, 2, and 3. Respondents number 4 to
14, lordship.
21.
4 to 20. 4 to 20.
Did you make paper publications?
Yes, madam.
Huh?
Yes,
Have you filed any affidavit to that effect?
yes, madam. Service complete, my lord. All the respondents have been represented.
No.
It was only 16 and 17. 15 and 16.
15 and 16. 15
15 and 16.
16. Only 15. I think.
15, only 15.
Our private respondents are not represented, although under orders of the court dated 1/3/2024, service of notice on respondents 4 to 8 and 10 to 21. What happened to 9? 9 is represented.
9, not open. Service complete, my lord. Or 9 also. 9 also represented.
By counsel.
Yes, madam. J. Burman. I ordered the 2410 people.
2410.
25.
Were permitted to make paper publications. Stop. In paper publications, by publishing notice in 2 local daily newspapers having wide circulation in the state of Assam, one in English and one in vernacular. Stop. Respondent 9 is shown to be represented by Mr. J. Bormal. Counsel. Thereafter, paper publication was made and where is the affidavit? On which date you filed? Thereafter, the laws in the court. Thereafter, it appears that the respondents 4 to 8, 10 to 14, 17, and 19, 17 and 19 to 21 were represented by counsel as per office note dated 2/5/2024. Subsequently, by office note 16/7/2024, it is reflected that respondents 9, 16 and 18 were also represented. So accordingly, all the respondents were represented by the council. Stop. The petitioner was is serving as he is now what, assistant manager? What is he serving as?
At present, assistant manager.
Assistant manager. And posted in Haflong branch.
Initially at Haflong branch.
Assistant branch managers.
He is now posted as assistant branch manager under the respondent bank. Stop. Petitioner was initially appointed as probationary officer under the bank on 16/12/2010. Stop. While the petitioner was serving as thus, the bank authorities proceeded to consider officers similarly situated like the petitioner for promotion to the next higher grade. Stop.
Grade D.
Grade?
Grade D.
D.
From
Grade D.
D.
From E.
D for Delhi.
Yes.
Grade D. Stop. According to the petitioner, he was placed at a higher position in the seniority list, which was published by the bank in the grade of assistant manager / assistant branch manager. according to the date of birth. Stop. In the said list, the petitioner is placed at serial number 3. Placed in the 3rd position. Stop. Thereafter, the selection committee proceeded to consider the cases of the petitioner and private respondents. Stop. Subsequently, by order dated 5/7/2021, the private respondents were promoted to the next higher rank, and the case of the writ petitioner stood overlooked. By order dated, by the impugned order dated 5/7/21, the petitioner has assailed the promotion of the private respondents promoting them to the next higher post, overlooking the claim of the writ petitioner. So there are 2 orders passed on 5/7/21, whereby the officers were promoted in 2 different sets. In none of the orders, the name of the petitioner figures. Stop. Petitioner represented before the authorities concerned, but the same was not replied to, and being aggrieved, the present writ petition has been filed, seeking a direction to the respondent authorities to consider his case for a mandamus to the respondent authorities for promoting him to the next higher post, and with all service benefits, including seniority. Stop. Whereas the respondent bank, represented by Mr. J.K. Goswami, has contested the writ petition by filing an affidavit. Stop. The learned counsel for the bank submits that on the day when the selection committee meeting was conducted for selection of the candidates, including that of the petitioner for promotion, he and 2 other officers were not considered in view of contemplated departmental proceedings, and accordingly, their cases were kept under seal cover. Stop. It is submitted that since the petitioner's cases were kept under seal cover, their cases were not considered, and accordingly, the private respondents' cases were considered and promotion orders were given effect to. In rejoinder, counsel for the petitioner submits that on the date when the committee had considered evaluated the candidates, cases of the candidates, including that of the writ petitioner, there was no departmental proceeding initiated, nor was any charge sheet issued to the writ petitioner. Therefore, the claim of the department or bank that his case was placed in seal cover is contrary to the law laid down by the apex court in Janaki-Raman, reported in so and so. Stop. It is submitted that unless the charge sheet and the charges are framed against the writ petitioner, departmental proceeding cannot be said to have been initiated, and therefore there is no requirement of placing the case of such a candidate in seal cover. Stop. Learned counsel for the petitioner also refers to the judgment of a coordinate bench of this court reported in rendered in Hiten Kolita versus State of Assam, reported in so and so, where the judgment of the apex court in KV Janaki Raman and others were referred to, and it was held by this court that unless the charges are framed, the case of the petitioner for in the matters of selection for promotion cannot be kept under seal cover. Stop. That is your submission?
Yes.
Anything more?
I cited three judgment,
One is Hiten Kolita, one is Janaki Raman, one is Anil Sarkar.
yes.
He is also referred to the judgment of Anil Sarkar, where the law laid down by Janaki Raman has been followed. Yeah. Counsel for the parties have been heard, pleadings available on record have been carefully perused. The short point which arises before the court is whether on the date when the selection proceedings were initiated, whether the case of the petitioner was required to be kept under seal cover, and whether any charges were framed against the petitioner on a date or prior thereto when the petitioner's case was considered for promotion, along with other similarly situated persons, including the private respondents. So, on a direction by the court, the standing counsel has placed before the court the proceedings of the board level selection committee meeting held on 11/2/2021. Which reflects that cases of the petitioner and the private respondents inter alia were considered by the appropriate committee for selection and promotion, for recommendation for promotion to the next higher post. Stop. In resolution 2, under resolution 2, the name of the petitioner is shown at serial number 4. And it appears that the names of the other private respondents are below the writ petitioner. Stop. Insofar as the writ petitioner is concerned, against his candidature, there is a remark within quotes, DP contemplated, quotes closed. Stop. There is also there is also the committee has also recorded a finding that the managing director of the bank had informed that a disciplinary proceeding action is contemplated against the writ petitioner relating to some major irregularities in respect of house building loan availed by the petitioner. Stop. A careful perusal of the committee the committee further resolved that the case of the petitioner along with 2 others be kept under seal cover. Stop. A perusal of the said minutes revealed that on a date when the selection committee meeting was held, which is 11/2/2021, there appears to be no departmental proceeding initiated and charges framed against the writ petitioner. Stop. The case of the writ petitioner along with two others were kept under seal cover as per the conclusion of the selection committee only on the information that a departmental committee or departmental action is contemplated against the writ petition. Stop. There. Whether a departmental proceeding is initiated by issuance of a show cause or the charges are required to be framed has been elaborately discussed by the apex court in the case of Janaki Raman, reported in 1991 4 SCC 109. Reference in this regard is required to be made to paragraphs 25, 26, 29. Extract code. The judgment has been consistently followed and by the apex court. One of the judgments referred to by the petitioner is Anil Kumar Sarkar, Supra, reported in so and so, where in a similar matter, the principle called out by Janaki Raman, Supra, has been followed. Stop. Closer to home, this court, the coordinate bench of this court has also referred to and relied upon the principle called out in Janaki Raman and followed in other judgments of the apex court that a seal cover procedure is called for only when the charges are framed in a departmental proceedings. Stop. Regard in this reference in this regard may be had to the judgment of Hiten Kolita, reported in so and so. A careful consideration of the law called out by the Supreme Court. There is no it is clear that a seal cover procedure in a department is to be resorted to, or by the department is to be resorted to only when the charges are framed against a delinquent officer. Stop. Mere contemplation of a departmental proceeding would not be sufficient to keep the case of any officer under seal cover during the process of selection, unless otherwise the rules of the organization specify in this regard. Stop. It is not in dispute that the bank rules do not specify or provide for any provision that contemplation of departmental proceeding is sufficient to keep a delinquent officer's case under seal cover during the time of selection by the selection committee. So, under such circumstances, this court unequivocally has to come to a conclusion that the process undertaken by the bank authorities in respect of the writ petitioner is in conflict with the law laid down by the apex court in Janaki Raman Supra. Stop. on the date when the selection committee was considering the claims of the writ petitioner, there was admittedly no charge sheet issued or charges framed against the writ petitioner. Stop. Only departmental proceeding was contemplated. So under such circumstances, the conclusion of the selection committee to keep the petitioner's case under seal cover and thereby not consider the eligibility of the petitioner for being promoted to the recommended for promotion to the next higher post is clearly contrary to the law laid down by the apex court and followed by this court. Stop. In that view of the matter, the writ petition is allowed. The mandamus is issued to the respondents to forthwith constitute a review departmental promotional committee or selection committee and to place the case of the writ petitioner for consideration as it stood on (11/2/2021). Stop. The committee, the bank authorities will place all relevant documents, including the APARs or ACRs, if required, as per the norms of the bank, and other relevant documents before the selection committee. Stop. The selection committee will thereafter consider the case and will promote the petitioner. Will consider the case and as it appears from the records placed before the court, and that there is no dispute that there was no departmental proceeding pending or charges framed against the writ petitioner as on 11/2/2021, the writ petitioner will be, the bank authorities will pass appropriate orders giving retrospective promotion to the writ petitioner with all financial and service benefits with effect from the date his immediate junior was promoted. Let this exercise be completed within a period of 30 days.
Lordship, 30 days, Lordship.
30 days.
30 days, Lordship. But Lordship, regarding the immediate junior, Lordship, the entire batch were promoted, Lordship. And from the date of
Immediate
promotion.
junior as per the select list
Yes, Lordship.
dated
Dated
22/1/2020.
22/1/2020.
What was the date to? No.
Select list, the next three.
Lordship,
Writ petition allowed this fourth
Put all benefits in the file.
with all benefits, service benefits and pay benefits.
Mark.
Writ petition allowed, interim orders if any stand March. Pending lies are also discussed.
Much.
Lordship.
Please, Lordship. In this matter, my lord, we are challenging a notification issued by the finance department. The finance department not yet filed their response, my lord.
Lordship, if it comes to the facts, Lordship, they are employees of Assam State Development Corporation for Scheduled Caste Limited, Lordship. And they are claiming benefits as per ROP 2017, Lordship. Now, Lordship, there is a notification of 2017, which says if the state level enterprises, Lordship, public undertakings, if they want to give the benefits of ROP, Lordship, to its employees, then first they have to adopt the ROP recommendations and they have to pay from their own resources. If Lordship comes to page 45, 45B. 45B.
Pleadings are complete here.
Not yet, Lordship,
Okay.
not yet. No, but I am showing this, Lordship.
Ah.
Lordship, this is a notification under 309, Lordship. And they are praying for setting aside of this.
Whatever you want to say, bring it on record if you want to file anything. You have to hear the matter.
No, if it is a 309 lordship,
Ah.
petitioners should approach the division bench.
They are challenging this, 45.
Yes, lordship. This is the basic challenge, Lord. They are praying for setting aside of this notification. Yeah, page 32. 32 lords.
Subject matter চাও একটু challenge to statute to আছে 309 mention করা আছে নাকি? All right, we'll call up after a while, let him examine. Next matter. Call up পিছত মাৰি দিম। ফোন কৰি সুধিলে হ'ল। Yes.
Lordship, we have received the instruction in this matter. Lordship, 2 weeks time may be granted to file affidavit.
Mr. Govildar, Planet Count, CGC,
On behalf of our BCGs.
on behalf of our Devi CGC submits that instructions have been received and they be permitted 2 weeks' time to file their affidavit. Counsel appearing for the petitioner does not object, list this matter after 3 weeks.
Item 9.
Yes.
Lordship. Lordship, in this application, Lordship, on the last occasion, Lordship, the respondents, Lordship, referred to a judgment of the Honorable Supreme Court, Lordship. 2020, volume 5, SCC, page number 462, Lordship. Lordship, in this case, Lordship, although in that factual situation, Lordship, the court may have, Lordship, considered that as the parties had chosen a place of venue and considered the place of venue as a jurisdiction. But however, Lordship, the law laid down in the very judgment, Lordship, comes in our favor, my lord.
Where is that?
Lordship, if I may take your Lordship, firstly, Lordship, to page number 469 now, Lordship, paragraph 14 of this judgment. Here, Lordship, a reference has been made to the Balco judgment, which is a 5-judge judgment, my lord. Paragraph 14. Lordship, if I may read paragraph 14, Lordship.
Yes.
First valence. As pointed out earlier, section 2(1)(e) of the Act defines court with reference to the term subject matter of the suit. As per section 2(1)(e) of the Act, if the subject matter of the suit is situated within the arbitral jurisdiction of 2 or more courts, the parties can agree to confine the jurisdiction in one of the competent courts. In paragraph 96 of Balco, the Supreme Court held that the subject matter in section 2(1)(e) of the Act is to identify the court having supervisory control over the arbitral proceedings. The Supreme Court held that the provisions in section 2(1)(e) of the Act have to be read in conjunction with section 20 of the Act, which gives recognition to the autonomy of the parties as to place of arbitration. The observations
No,
in paragraph
here,
10.
here the question is whether, because your contract was not very specific.
Contract
Just-
was not specific.
It just said that arbitrations will be held in Noida.
Lordship, when
Now, whether it is the venue or it describes the seat.
Lordship, here, Lordship, venue and seat, both are two different concepts, Lordship.
No, that is all right, but in your agreement,
Lordship.
what was the intention?
Lordship, according to us, only the venue, Lordship. It's only the venue because jurisdiction has not been decided and seat also has not been provided for, my lord. Only the venue. And Lordship, in such cases, Lordship, it is for the arbitral tribunal, Lordship, under section 22 to decide upon the seat.
That is all right, but assuming we accept your arguments and we refer you to an arbitrator from this High Court, they are questioning the very jurisdiction of this court under 11(6) by placing a reliance on this judgment.
That I understand, my lord. That I understand. But lordship, our
It is not a case of whether the arbitral tribunal would be competent to decide X matter or Y matter.
lordship,
It's, they are questioning that court will mean the principal civil court. Therefore, the court which will have jurisdiction to decide
yes, lordship, but
will be the
lordship,
court, is the referral court.
I understand lordship.
So under 11.6, in view of this agreement, this court does not have the jurisdiction.
Lordship, but paragraph 18, only the first line, my lord. The law comes in our favor, but the decision was against us, lordship,
Yeah.
in this case. Because
That's
paragraph 18 is, lordship, where the contract specifies the jurisdiction of the court at a particular place. Only such court will have the jurisdiction to deal with the matter and parties intended to exclude all other courts. Thereafter, lordship, the decision was that venue will be the jurisdiction. But lordship, the law is that only when jurisdiction is lordship settled, then only lordship that particular court will have.
So what are the clauses in this particular contract? I think it is similar.
Yes, exactly similar. The
Hmm.
condition of the contract, your lordship will find that clause 18 referred to in para 4, 465. That is the exact clause in which is been, which has been para 4, page 465 of the judgment.
465.
And exactly similar clause is there in the present case.
Venue of the arbitration.
Yes, and in this case also, in the case in hand also, my lord, it has been reflected just like that. The venue of the arbitration shall be at Noida.
This judgment perhaps is again subsequently followed by
Yes.
another judgment.
Yes.
Reiterating this.
Lordship, that is there, but lordship Balco, which is a 5-judge judgment, Balco, lordship says, lordship, there will be jurisdiction of 2 courts. One where the cause of action arises or part cause of action arises, and the other court will be where the arbitration takes place.
That
Lordship.
argument you'll have to make before the apex court.
But lordship, here lordship will be, lordship, we should be going by
course we
the
can-
judge bench.
You
lordship.
give us, refer to the judgment, take us through the 5-judge.
Lordship, Balco is at page, lordship, paragraph 14.
Not like this. You have to take us through the Balco judgment. Not by making references from here.
Lordship,
You have to take us through that judgment.
lordship,
To
please.
say that this was the subject matter for which this matter was referred, a larger bench decided it in this term. And this interpretation is still the law and has been wrongly interpreted. We'll see what can be done then. You have to refer the judgment. And point out that the interpretation in Balco has not been correctly interpreted here.
Otherwise, lordship, there is another case, lordship, of a 2-judge bench of the Supreme Court, where also, lordship, there has been a distinction, lordship, between sections 20 clause 1, 20 clause 2, and 20 clause 3. 20 clause 1 and 2 pertains to C, and 20 clause 3 pertains to the venue, lordship.
Where?
Lordship, in this judgment itself, lordship,
This is a 2-judge bench.
paragraph 17, my lord. Paragraph 17, interplay between seat and place of arbitration came up for consideration in Indus Mobile Distribution. Thereafter, lordship, it was in referred paragraph number 18, just below that. The amended act does not, however, contain the aforesaid amendments, presumably because the Balco judgment in no uncertain terms has referred to place as juridical seat for the purpose of section 2(2) of the act. It further made it clear that sections 21 and 22, where the word place is used, refers to juridical seat, whereas in section 20 clause 3, the word place is equivalent to venue. This being the settled law, it is found unnecessary to expressly incorporate what the Constitution Bench of the Supreme Court has already done by way of construction of the Act. A distinction has already been made, my lord, in this very judgment.
You have to show us that this conclusion is not binding on us by giving references that
Even
Where-
lordship, in this judgment, the law which was, the decision which was taken may be against us, but the law which was settled comes in our favor, Lordship. Paragraph 18, Lordship.
No, para 18 has only said that parties have agreed that the venue of arbitration shall be so and so.
But the first line comes in our favor because jurisdiction clause has to be there. In our agreement, there is no jurisdiction clause. But thereafter, Lordship, the decision goes against us. But the law is in our
No,
favor.
no, the ratio of the judgment is wherever you have decided on a venue or the parties have agreed that we want to continue with arbitration will be the jurisdiction of that court.
But the first line, Lordship, also lays down a law, Lordship, which comes in our favor in this case.
Where,
The
where? First
distinction-
line is not in conflict with the other paragraphs of the judgment. First line of para 18,
18, ma'am.
please read.
But where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and parties intended to exclude all other courts. Till here, Lordship.
So
there's a
where is the
distinction.
jurisdiction described here?
Here,
In your case?
in my case, Lordship, there is no jurisdiction in our arbitration.
That is
clause.
what the court is trying to say.
Till here, Lordship, a distinction is there, but thereafter, Lordship, when the decision in pertaining to that factual matrix, Lordship, decision was taken, it goes against us, fairly submitting, my lord.
In your contract, there is no jurisdiction.
No jurisdiction, my lord.
So therefore, perhaps this is what the court is trying to say, that in the contract before the apex court, also there was no jurisdiction. Only the venue was decided. Therefore, the court said this is the agreed venue or jurisdiction of the decided by the parties. Arbitration Act. See, even interpretation of para 18 is against you. Para 17 of the judgment, where para 18 of Balco is interpreted. Please read it again.
Paragraph 18, ma'am.
Now, para 17 of the judgment, where para 18 is reproduced.
The amended act does not, however, contain the aforesaid amendments, presumably because the Balco judgment in no uncertain terms has referred to place as juridical seat for the purpose of section 2, clause 2 of the act. It further made it clear that sections 21 and 22, where the word place is used, refers to juridical seat, whereas in section 20.
Now you stop here.
Oh, sure.
Where the place is used refers to juridical seat.
Seat. Where the word place is used.
So if you come to 20, section 21 and 2,
Oh, sure.
come to section 21 and 2.
Section 21 and 2, Lordship.
Yes.
21, the parties are free to agree on the place of arbitration.
Place of arbitration.
Lordship, that we have not done it.
All right, then
22, failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties.
now, yeah, then you come to 3.
3. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the
See,
parties.
Therefore, 21 and 22 are left to the parties. 21 and 22 are with regard to the parties.
Lordship, in my submission, my lord, 21 on the parties.
Huh.
Parties failed. Parties did not agree. Now 22 will come in our case. The arbitral tribunal will decide the seat.
No,
We have only, lordship, complied with 23.
you have, see, you want to say you have agreed on the venue.
On the venue. That's why
Right.
23 is not required in our case,
No, so you want to say that you have agreed on the venue.
lordship.
Now, under section 20, in which subsection have you agreed for the venue?
That's why I'm saying, lordship, subsection 3, lordship,
Hmm.
it won't, lordship, it won't fall in our case because we have
Exactly.
already agreed to meet at a place, that is
Right.
Noida,
Subsection 3 is out.
out.
Now, 21 and 22,
Out of 21 and 22,
Hmm.
parties are free to agree on the place of arbitration.
Hmm.
That we have not done,
no. I am asking you
lordship,
that you have chosen a venue.
lordship.
There is no dispute that you have chosen
Yes,
a place. Under what provision have you done it?
lordship, because
Under what provision do you
says-
think will it come?
3 says notwithstanding subsection 1 and subsection 2. Subsection 1 and 2,
That is-
apart from that.
23 is for the arbitral tribunal. We have not even gone that far.
Lordship, 23 arbitral tribunal will come into place unless otherwise agreed by the parties to meet at a particular place. We have agreed to, the venue is Noida. We have agreed upon that. Now, lordship, now in this case, subsection 1, we have not done. Now 2 will come in place. The arbitral tribunal will decide the seat because we have not adhered to 1. And 3, lordship, it's not, there is a notwithstanding clause, lordship. And moreover, lordship, the arbitral tribunal will decide on the venue only if the parties have not agreed. We have agreed on the venue. Now only for section subclause 2 to come into play.
Then how do you interpret the Balco judgment to that effect?
Because Balco judgment, lordship, here it is Balco judgment, not in lordship paragraph 13, it's the Indus Mobile judgment. Here it says, further made it clear that sections 21 and 22, where the word place is used, refers to juridical seat, that is a jurisdiction, which will lordship determine the jurisdiction. This being, whereas section 23 word place is equivalent to venue.
Hmm.
Therefore, there is a distinction, my lord, between 1, 2, and 3.
You show us the judgment, we'll have to go through that. Balco,
Lordship Balco and Indus Mobile, Lordship Balco.
you will have to go through it. Mr. Doctor,
Yes, my lord.
it can be interpreted.
No, my lord,
It-
our case is that it is under 21.
No, that's all right.
It is under 21 and Balco will not come on our way.
See, 21 is to free to agree on a place of arbitration.
Yes.
It can be interpreted to mean, as you have sought to do it, that we have already agreed
Yes.
that place. So that place will determine the juridical place.
Yes.
They say that no, this is not 1 or 2, it is 3. Because 3 also has 3 in terms of Belco falls into a only in respect of the venue.
Perhaps, my lord, it can be looked into like this. 3 will come into operation
Only after 1.
only after 1. And my lord, it is just a place for meeting the arbitrators. It comes into operation at a stage when the arbitrators have been appointed and decides to hold the meeting. Because if your lordship will read the further lines, at any place it considers appropriate for consultation among its members,
Including
for
hearing-
hearing witnesses, for hearing experts or the parties, and for inspection of documents. The purpose is this. So it comes into operation only after the arbitrators have been appointed. It cannot come, my lord, prior to appointment of the arbitrator. The objective of sitting at a particular place as per the convenience and decision of the arbitral tribunal, the objective has been delineated here.
Yes.
Lordship, but it starts with a non-obstante clause, Lordship.
The
Notwithstanding,
non-obstante clause is with
notwithstanding.
regard to 1 and 2.
So that is what we asked you, that clause 3 will come when the arbitral tribunal is already constituted.
Lordship need not be, because unless otherwise agreed by the parties, if the parties have already
That is
agreed.
with regard to the place.
No, this is with regard to a venue, Lordship. With regard to
Place
venue.
or venue or whatever you say.
Unless otherwise agreed by parties.
Huh.
Here we have agreed. So 3 doesn't come into play.
You
in
have,
our case.
all right, you have agreed, but you have agreed, if you agree, then it can only be for the purposes mentioned in 23.
3, Lordship.
Only for the purposes mentioned.
Yes, Lordship.
And that is at the option of the arbitral tribunal.
That's why, Lordship.
So what is the purpose of these? What is the purpose specified in 23?
23, Lordship, for the purposes here, Lordship set herein, for hearing witnesses,
That's right.
experts, etc., Lordship.
It does not, it cannot contemplate that the arbitration will continue in this place.
Yes, Lordship, that I understand. But for
So
not,
if that be so, then what is the point in selecting a venue for arbitration?
Lordship, that's why, Lordship, venue was selected, but juridical seat was not selected, Lordship.
Venue, you say, all right, let us accept your argument that venue was selected for what? For arbitration? Or only for
conducting
these
the-
purposes?
Lordship, for these purposes, Lordship, for conducting.
Where is it again in your agreement?
Lordship, it's at page 84 of the additional affidavit.
84 of the additional evidence.
Lordship, the arbitration clause starts here. And Lordship, in page 25, Lordship, this stated, the venue of the arbitration proceedings shall be at Noida.
Right. The venue of the arbitration proceedings is not arbitration. The venue chosen is not for hearing of witnesses, experts, inspection of documents, goods or property. 23 is restricted only for this.
Lordship. Therefore,
That's what the
venue,
statute
Lordship.
says.
Therefore, the word venue, Lordship.
Correct, but not for the arbitration proceedings. It's only for these purposes. You see the the term of section,
Lordship,
wordings of section 23.
for consultation, for hearing witnesses, for inspection, goods and other properties.
That's right.
Venue is for that purpose, and for that venue is at Noida.
All right.
But for Lordship, seat, Lordship, nothing has been given in the arbitration agreement, Lordship.
No, if we go by your the language used in the clause, it says venue of the arbitration proceedings. The term used is arbitration proceedings.
And that is what in Brahmani River, my lord, that is the interpretation, that if this is indicated in the contract, then it will be the place.
Where was the agreement executed?
Agreement
Noida.
was executed in Noida.
On the contract? Works?
Work was at Guwahati, in Assam, Lordship, different places, 3 different places in Assam. Therefore, Lordship, part causes of action is under this one.
What is the context? What is the effect of cause of action? Ultimately, you are following the civil procedure.
No, cause of action is there. But if your lordship will also see why they are coming for arbitration, because of the rejection order. They wanted the liquidated damage not to be, liquidated damage to be waived. That order was also issued from, impugned order was also issued from Noida. It is not for the cause of action for the arbitration is the order which rejected their claim for waiver of liquidated damage. That was also from Noida.
No, but the-
Only the supply that they were supposed to do or the service that they were supposed to render, that was within the jurisdiction of the state of Assam. Geographical,
they are business based in Assam.
Yes,
they
Lord.
are
based in
business
Assam.
based, yes.
And also,
And they were to supply the service within the states of Assam, within the state of Assam. But the contract was executed at Noida and the order rejecting their claim was also issued from Noida.
Lordship, here my submission is that Lordship, work was executed at Assam. Everything was here. The witnesses, Lordship, everything has to be examined here. In fact, Lordship, the chief engineer, the person who was in charge of this contract,
You show us that the normal principle of cause of action as is arises or as is followed under the civil procedure is equally applicable here.
section 2(1)(e), Lordship, of the arbitration.
2(1)(e).
E, Lordship.
It's court means principal civil court.
Lordship. Principal civil court of origin jurisdiction in a district and includes high court in exercise of its ordinary origin civil jurisdiction.
What if instead of arbitration, they had proceeded to
File a suit. Well,
In
that
what?
is also excluded by the clause in the contract. Supposing there is no contract,
There is no contract. There is no arbitration.
there is no, in that case, possibly that could have been the scene that they would also have the liberty to,
But for the agreement.
yes. But for the agreement and the restrictions put therein, they have bound themselves by the clauses. And it is not only about, courts in Assam, it is also about courts in any other place other than Noida. The principal civil court of jurisdiction will be in the state of UP.
You come back again with some more judgments, we'll see.
But practically, my submission is that it can be closed.
Lordship, and-
Although we are having an objection also on the on the count of limitation, my lord. But on this ground,
No, going by the judgment of Brahmani.
That is clear, my lord.
Followed. There's no doubt on that, unless you want to distinguish it by referring some other judgments or an interpretation which is otherwise not being noticed by the court.
In that case, Lordship, next week, Lordship, is meant.
There is a subsequent judgment to this. Please get it out. Very recent. Yes, Mr. Dotto.
Yes, my lord. I did not bring that because this categorically refers to our case. The fact situation and the clause exactly identical, my lord. That's why I placed this one.
That's okay, but we are asking them to bring it. We'll keep it for next week.
Lordship.
My lord, next week, little time. If it can be on 19th or 18th or 19th is Wednesday, 20th.
20th. All right. Let it be on 19th.
19th is Wednesday.
We'll make an attempt. 19th of November for further hearing
Yeah.
on 19th of November.
Oblige me.
Did you?
I think several.
What are you challenging the notification?
Lordship, page number
Page?
Page number 45.
45.
45. But this is not a rule. Is this a rule?
Yes, if Lordship comes to the first line, Lordship,
Uh,
in exercise of the power conferred by the proviso to Article 309 of the Constitution.
yes, but this is what? Is this what is the name of this rule?
This is a notification, Lordship.
It's a notification.
Maybe Lordship, but in spite of that, it was issued under proviso to 309. Governor of Assam. 166. Constitution.
It is only for making rules. You see 309.
Conditions of service.
No. Conditions of service, you have to read it with the rules.
Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or of any state, provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union and for the governor of a state or such person as he may direct in the case of services and post. Lordship, that rule is not specified anywhere, Lordship. So it is if Lordship comes to the second line, in exercise of power conferred by the proviso to Article 309 of the Constitution of India, the Governor of Assam. So basically, this is an instrument issued under 166. So that is why, and the rule is if it is issued under the proviso to
This is not a
309,
rule.
Lordship.
This is not a rule. You have not framed a rule. 309 is, normally you frame a rule pursuant to a statute.
Yes.
Normally you have a statute. It comes, then you frame a rules for implementation of that. 309 proviso is where you don't have a statute, you bring in the rules.
Lordship, in some cases, even without having a act, Lordship, rules may be framed, Lordship.
That is what the purpose of 309 is.
Yes.
That's what we are saying.
It
but-
is exactly that it is, Lordship.
But this is not a rule.
Lordship,
What is
that,
this rule called?
Lordship, that ROP rules is also a rule of under 309, Lordship.
What is the name of these rules at page number 45? How do
Name
you
is not
define these
there.
rules? It must have some nomenclature,
Yes. It is issued as a notification.
notification, it's not a rule.
But in spite of that, Lordship, it is an instrument, Lordship, under 166.
It may be, maybe. Every notification is issued under one, powers will have to be traced to 166.
But in that situation, Lordship, I have to elaborate, Lordship. But in my understanding, Lordship, it was issued under 309. It may be a notification,
309 is
it may be a
mentioned,
rule,
but
Lord.
what is the name of the rule?
Name is not there.
You show us from 309 that any notification memorandum will also have the standing of 309 rules. 309 is where you urgently need set of rules,
Yes.
which will operate as a statute. Till such time the proper service rules, etc. are framed.
Yes, Lord.
That's the whole purpose. Therefore, it is given the value, the status of a statute.
It has not been named as a rule, Lordship, but in all practically, Lordship, these are rules that is applicable to all state level public enterprises.
You show us from some authority that any notification under 309 will also be a rule. Because the High Court notification is clear, statutes or bodies of acts or rules.
Yes.
It's not a rule.
But there are certain rules, Lordship, which were issued in terms of the provisions of that particular act. And some other rules are there which are issued under 309.
We know that.
Yes.
But you tell us the name of these rules.
So, so far as in terms of this particular notification, we cannot refer it to any particular act, Lordship. But in spite of that, Lordship, these are rules under 309.
You show us that it is a rule under
Lordship,
309.
Lordship.
You show us. Third Council for Parties, the Learned Counsel for the Respondents, Finance Department submits that the challenge in the writ petition is annexure capital E, page 45. Which was framed under Article 309 of the Constitution of India. And therefore, any challenge made. So, and therefore, any challenge made to such 309 rules ought to be placed before the division bench 1 as per notification number 43. So, the Learned Counsel for the Finance, however, fairly submits that the notification impugned, which was issued by the Department of
Finance Department.
Finance,
Finance PRU Department.
PRU Department, dated 17 January 2018, is a set of rules, although there is no specific mention there too. He, however, submits that he would like to elaborate on this aspect by making appropriate submissions on the next date fixed list accordingly. After 2 weeks,
Lordship.
Mr. R. Horford, or respondent,
4 and 5 months.
4 and 5.
Your lordship, a date may be fixed.
27th,
November.
Lordship in the.
sorry,
first-
not
first week, Lord.
27,
In the first week, Lord.
first week.
First week.
Right, then
No, December.
No.
4th of
4th, Lord.
December.
Yes.
All.
Obliged.
Yes.
Also, register, stoppage of the 2 increment lordship, petitioner is a constable lordship. And his increment is stoppage, 2 increment lordship. The duty departmental proceeding, lordship in order come to the, page 61 lordship. Page 61 in order. Annex 7.
Did you file an appeal?
Yes, lordship.
What was the order?
Order is annexed, lordship 13 lordship, page 83 lordship. My appeal was rejected on just because of time bar lordship.
Time bar.
Yes, lordship. Appeal which are time bar on that ground lordship. Because of.
When
lordship-
was the order passed?
Yes, lordship.
When was the order by the disciplinary authority passed?
About 21.
29 October.
Yes,
And you filed it on? Appeal you filed on
bill file on lordship,
16/12.
yes, lordship,
16/12.
16.
Why should we interfere with the punishment?
Yes, lordship, kindly see the, lordship, he approach, dispose of, lordship, it may be revived as per the honorable court order, lordship, in the impugn order is mentioned here, lordship, DP is disposed of due to, and as per revived, lordship, because the trial is going on, lordship. Has been going on, and after the acquittal, I have appealed this, department, lordship, appeal. And after that, lordship, they have rejected the, because of time bar. I have, everything explained, lordship, due to my trial is going on, and so that I could not appeal it in that time. And in impugn order itself mentioned, after the honorable court order, it will be revived.
What is the limitation for filing an appeal under the rules?
3 months, lordship.
Then how can we extend the limitation?
Yes, lordship, due to the lordship, trial going.
Whatever
on,
it may be,
that's-
but after it is expired, how can we extend the limitation? The rules say 3 months.
Yes, the rule says 3 months, lordship, but lordship, he has mentioned, that's why I have not approached earlier, lordship.
as per the honorable court, trial is going on. If I approach that time, Lordship, they will be said after the trial, you will become something like that, Lordship. That's why I was not approached, Lordship. After the trial court acquitted, Lordship, immediately I was file appeal. I have filed appeal.
Where is the appellate order?
Next at 13, Lordship.
8?
Page 83, Lordship. 83 is type copy, Lordship, 82. Trial court order.
Yes, respondent.
Lordship, yes, because their only ground is that the petitioner has been acquitted. So this cannot be the ground, Lordship.
We refer it to the, remand it to the appellate tribunal to decide.
Lordship,
The
it will
order which is given here,
Lordship.
we do not know whether this extended the proviso for consideration of sufficient cause was done or not.
Lordship may,
83. So on that ground, they will examine.
Lordship.
Yes. Heard learned counsel for the parties. This writ petition is filed with the petitioner, aggrieved by the imposition of punishment by the respondent authorities on the petitioner. Where is the order of the disciplinary authority?
So next at 7, Lordship, page 61.
61. By order dated 29/10/2021, whereby the disciplinary authority on the findings submitted by the inquiry officer in connection with DP number 01/2019 drawn up against the petitioner, awarded stoppage of 2 increments with cumulative effect. Stop. It is also ordered in the said, it is also mentioned in the said order that the departmental proceedings and the order may be reviewed later as per honorable court's order. So learned counsel for the petitioner submits that being aggrieved, she had filed an appeal under section 16 of the Discipline and Appeal Rules 1964, which came to be rejected on the ground of being time barred by order dated 17/2/2025 issued by the appellate authority. So, it is submitted by the learned counsel for the petitioner that in the impugned order passed by the departmental disciplinary authority, it was mentioned that the disciplinary proceeding and order may be reviewed as per the honorable court's order. And at present, the trial is going on.
No, Lordship, it's acquitted, Lordship.
He is acquitted.
Yes, Lordship.
Okay. And at present, the petitioner has been acquitted of the offenses alleged, of the offenses he was charged by. Do you have the date of the order?
Acquitted, Lordship, 18th November, Lordship, 2024.
By order dated 18 November 2024 in, what is the details? Proceedings?
That trial order.
Paragraph? in the proceeding.
41 is the trial order.
41.
Yes, Lordship. It's 41.
In PRC 24 of 2022.
PRC number.
Stop. The learned counsel for the petitioner submits that without considering the order passed by the trial court acquitting the writ petitioner, the appellate authority by the impugned order dated 17/2/2025 dismissed the appeals preferred by the petitioner on the ground of being time barred. Stop. There. The counsel appearing for the respondent submits that there is no infirmity in the disciplinary proceedings undertaken and no interference of the orders passed by the disciplinary authority or by the appellate authority is called for at this stage. Counsel for the parties have been heard. The writ pleadings available on record have been carefully perused. Stop. It is seen that pursuant to the writ petitioner being pursuant to the disciplinary authority imposing the punishment or stoppage of 2 increment. Where is that disciplinary punishment order again?
61 page, Lordship.
61.
Being issued imposing stoppage of 2 increments with cumulative effect and notwithstanding that, and also the said order clearly mentions that the DP and the order may be revived later as per the Honorable Court's order. Stop. Thereafter, the trial court in PRC 24 of 2022 by order dated 18/11/24 delivered a judgment and order acquitting the petitioner of the charges framed under section 406. Stop. Subsequent thereto, by the way of the impugned order dated 17/2/2025, the appeal preferred by the writ petitioner stood dismissed on the ground of limitation. Stop. From the order, from the recital of the order passed by the appellate authority, it is not clear whether the order passed by the trial court by order dated 18/11/24 in PRC 24 of 2022, as well as the liberty given by the disciplinary authority in the order imposing punishment on 29/10/2021 was considered, was taken into account and considered. Stop. Rule 17 of the Assam Services Discipline and Appeal Rules 1964 provide for a limitation in filing appeal against orders passed by disciplinary authority. Stop. The appeal against any such order was required to be filed within a period of 3 months from the date on which the appellant receives a copy of the order appealed against. Stop. Proviso to Rule 17, however, permits the appellate authority to entertain an appeal after expiry of the limitation period if it is satisfied that the appellant had sufficient cause for not submitting the appeal in time. Stop. The impugned order dated 17/2/2025 passed by the appellate authority does not reflect as to whether these aspects and the provisions of the rule were considered. Stop. Under such circumstances, this court is of the considered view that ends of justice will be met if the impugned order dated 17/2/2025 is interfered with and the matter is remanded back to the authorities for a fresh consideration. Stop. It is therefore ordered that the order dated 17/2/2025 passed by Assistant Inspector General of Police within bracket AP Assam Ulubari Guwahati as the appellate authority, dismissing the appeals filed by the petitioner on the point of limitation is interfered with and set aside. Stop. The matter is remanded back to the appellate authority. The appellate authority will now redecide the matter. Taking into consideration the grounds as may be urged by the appellant before the authority, explaining the delay that had occurred in filing the appeal beyond the period of limitation. Stop. The appellate authority will also consider the order passed by the trial court in PRC 24 of 2022, dated 18/11/2024, read with the liberty granted by the disciplinary authority in its order dated 29/10/2021. Stop. The appellate authority, on hearing the petitioner and considering such grounds as may be urged, along with the provisions of the rules and the orders passed by the trial court, will reconsider the matter and pass appropriate orders as expeditiously as possible within the outer limit of how many months? 60 days.
Lordship, 60 days will be 2 months, Lordship. Oh, yes, Lordship, 90 days, Lordship.
90 days.
90 days.
90 days from the date of receipt of a certified copy of this order. Writ petition allowed, disposal.
What's up?
No order is to post.
Deeply obliged, Lordship.
Item 11.
May I please, Your Lordship?
Yes.
Petitioner has challenged her rejection of her candidature in the 2024 recruitment. Her candidature was rejected because, Lordship, while filling up the online application form, the internet cafe operator made a mistake and selected Gujarat tribe category, whereas she belongs to OBC category. The petitioner is a female. She resides in the district of West Karbi Anglong, in a village which Your Lordship can consider one of the remotest villages. She never had access to computers either at school or at her home. In 2024, the respondent SSC, Staff Selection Commission, they issued a advertisement for recruitment to the post of Constable GD. And being an OBC candidate, Lordship, she filed her application. However, Lordship, while filling up the application form, Your Lordship will find that page 79.
When did you realize that this was a mistake?
When the detailed medical examination was conducted, wherein the documents were sought for in respect of the category wherein the mistake was crept in. At that point of time, she realized that the mistake was committed.
She is a victim of, she's not a victim of riots.
No, Lordship, absolutely not, because she never resided in Gujarat, Lordship.
Then
Actually, what should have been done at page 79, Your Lordship will find serial number 15.1. Whether is seeking age relaxation? Yes. As Your Lordship got page 79. 15.1, whether seeking age relaxation? Yes. 15.2, if yes, age relaxation code 04, children and dependent of victims killed in the 1984 riots or communal riots of 2002 in Gujarat.
what is the age relaxation she wanted?
Lordship, because by that time, at the time of filing up application, she was almost 6 months above the age.
No, no. What are the criterias in which age relaxation is granted?
Lordship, that your Lordship will find at in the advertisement itself. Page 22. The column should have been, the code should have been 0.2, whereas the internet cafe operator made a mistake by clicking 0.4. 0.2 OBC, 3 years. So otherwise also she would be getting the benefit of age relaxation.
No, no, sorry. You are referring to page 22, the serial number
5.
5.
Age limit.
She is OBC.
She is OBC.
She is entitled to 3 years.
3 years.
All right. Then she
What-
must have seen 5 years.
Yes, she selected 4. At serial number 4, your Lordship will find children and dependent of
He
victims.
wanted the maximum benefit, 8 years.
That is for OBC and 4. So that mistake
Then
had
how
taken
can
place.
it be rectified? When did you fill up the forms?
Lordship, in the year 2024.
And when was the error brought to you or you
Lordship,
noticed?
Lordship, after clearing the physical.
Which year?
2024, Lordship.
But how does anybody know that this is a bona fide mistake? Bare statement?
Lordship, otherwise also she would be getting the benefit of 3 years.
How do we know whether carelessness is a ground to be condoned?
Lordship, that is what the advertisement. Then that case, Lordship, I will take your Lordship to the advertisement. Because page 36, Lordship. 36 of the advertisement, serial number 12. Medical examination.
Yes.
Your Lordship will find serial number 12, 12.6.1.6. Caste certificate is applicable in the format prescribed at Annexure 6, Annexure 7, and Annexure 8 of the notice from the candidate seeking reservation age relaxation. So the respondent provides a format which has to be signed by the district magistrate of the concerned district wherein the petitioner belongs. This they have to submit at the time of detailed medical examination. Now, once this is submitted in terms of their format, at page 25, your Lordship will find the process of certification and formats of certificates. Because clause 6.1 of the advertisement says that once a candidate fails to submit the document which they selected, then they will be considered in their original category. Here, her original category is OBC. And a format which is
Where do you say that condition is?
at page 25.
25. Yes.
6.1, Lordship. Candidate, may I read, Lordship? Candidate who wish to be considered against reserved vacancies or seek age relaxation are required to submit requisite certificate from the competent authority in the prescribed format. When such certificates are sought by concerned CAPF for document verification at the time of DME, otherwise their claim for SC, ST, OBC, EWS category will not be entertained and their candidature applications will be considered under unreserved category. Further, if a candidate has sought any other age relaxation or claimed ESM status, that any other will fall that Gujarat Riot category and is not able to produce the relevant certificate, he will be considered in his respective category, that is ST, SC, OBC, EWS or unreserved. The formats of certificates are annexed with the notice of examination. So they prescribed a format. In that format, the district magistrate issued a certificate. She submitted it before the respondent authorities at the time of detailed medical examination. During the detailed medical examination, the respondent had sought a certificate showing that she belongs to Gujarat Riot category, which she does not have at all. Because she never resided, her family never went to Gujarat, Lordship, to be affected in Gujarat Riot.
So what do you say?
Yes, Lordship.
he, first of all, he submit the application. He, at first, he stated that his category is unreserved. Kindly come to page 79, Lordship. Here, this is the application. And here he does not mention anywhere that he was from OBC, she was from OBC category. Here, 0.8 category,
Hmm,
unreserved.
where?
Page 79
Oh,
from right side,
hmm,
point number 4, point number 8. Top, there is 4.
unreserved.
Yes, he never, he does not say that he is, she is from OBC category. After that, kindly come to page 25, Lordship. 6.3
Hmm.
for regarding the certificate which he has to be submitted at the time of making application, Lordship. Here,
Okay, what is the age for general category?
18 to 23 years. The candidate has to bond as per the advertisement before, should not bond before earlier than 2/1/2001. So she,
at the time of she submit the OBC certificate at the time of DME, Lordship, and she never submit the OBC certificate at the time of application. And 6.3 of the notification, page number 25. Here it is mentioned that crucial date for claiming SC, ST, OBC, EWS status will be the closing date for receipt of online application. And the closing date of online application is, kindly again come to page 79, Lordship. No,
page 20.
page 20, Lordship.
1/1/2024 was the closing date.
1/1/2024. And his OBC certificate is applied on, issued on 5/8/24.
You say you are OBC, but you have chosen unreserved.
And OBC,
No, that mistake, that is why Lordship, she is before you.
So many mistakes.
Because Lordship may kindly consider that this candidate, who is a female, she studied in a Hindi medium school in West Karbi Anglong.
These are not
She
relevant.
had
There is a
never
form-
access to
there is a
computers.
form. If you don't know, you don't understand, you ask somebody. I can
And crucial
understand
date of
that, right, okay. But you said you belong to OBC, but your form reflects you are general category.
Lordship, by selecting unreserved category or Gujarat Right category, she would not be availing any benefit, because otherwise also being an OBC candidate, suppose had she selected OBC candidate, that in that case also she would be getting the benefit of 3 years. Therefore, this is not a case that she made a mistake by knowingly to get a benefit. which
OBC
is just 3
certificate,
years.
see, Lordship.
General category, there is no benefit.
Yes.
You are overage otherwise.
Yes,
No,
Lordship.
she being an OBC candidate, she is not overage.
No. But OBC you said, but in the form you did not reflect OBC. 79.
Yes.
In that case, I'll take your Lordship. There are 2 modes of application. They provide 2 modes of application. First, the candidate has to make a one-time registration. At page 47, that during that one-time registration, the candidate has to opt whether on which category she actually belongs.
Where have you registered that?
Page 47. One-time registration, part 1. At page 48, serial number R, serial number 11, provide information about your category. Has it, Lordship, got?
That's right. What have you provided for?
OBC, Lordship. That
Where?
during the motion stage, I have already provided a copy of that, Lordship. এখন video.
But why should anybody be so concerned about you, about making mistakes and rectifying all that? Why? How can you make mistakes with your category, with your age relaxation benefit? How can this court come to a finding that it was a bona fide mistake? Because admittedly, the relaxation for the category you have chosen is more.
Lordship, because if she really wanted the relaxation, age relaxation in terms of the Gujarat Rat
It's
category.
not about whether she wanted or she did not want. It's a
Lordship.
question of a selection process.
Lordship.
In the selection process, you are supposed
Your
to be
Lordship-
careful about filling up.
Your Lordship may kindly see the page which I have provided just now.
Hmm.
Serial number 11 at the top of the page, your Lordship will find OBC. She clicked OBC during the one-time registration. The mistake scrapped in while filling up the online application form. And therefore, the clause 6(1) will come into rescue in
This
favor
is
of the petitioner.
registration for what?
This is the part 1 provided in the advertisement.
How do we know you have chosen? It's not clear from here. OBC. You are referring to serial number
11
A.
category.
It says general EW as OBC. We don't
OBC.
know. Doesn't appear to be very clear. It doesn't appear whether you have chosen OBC.
Lordship, your Lordship can see the mark in the OBC.
I
column.
cannot see it. Therefore, I am asking you.
So, এখন copy আছে। এটু copy অলপ ভাল আছে।
Can't see it. Not clear.
Now I cannot take a printout of this because they have already closed the window. And having selected the OBC category, they accepted her candidature. And while filling up the online application form, which is provided as a part 2 of the registration in the advertisement, that mistake,
No, see, you have filled up by mistake.
Lordship.
And you don't even realize that there is a mistake.
Lordship,
Until you are presented before the medical board or medical thing.
because Lordship, there is no question of realizing at the time of.
That means you're casual, you're careless. Why should the court be inclined to give you an order if you're so careless?
Because Lordship,
It's a matter of your livelihood.
I understand, Lordship.
Then you are applying for discipline forces
Lordship.
and you are not an illiterate person.
She is a literate person, Lordship. But the fact remains that she never had access to computers.
That-
And therefore
Neither
she
here
had
nor
to,
there.
therefore she had to go to 5 kilometers away from her home for filling up the online application form.
Yes, what do you say, madam?
Yes, Lordship, so it cannot be, even in the case of OBC certificate, there is a terms in the notification, Lordship. Kindly come to page 25, 6.3. Crucial date is fixed by the authority, and it is, it should be the 6.3. Crucial date for claiming SC, ST, OBC, EW status will be the closing date for receipt of online application. And closing date is 1/1/24, and his OBC certificate's date was 5/8/24. Kindly come to page 18 of the writ petition, Lordship.
Page?
Page 18 of writ petition. Petitioner submit his OBC
This is
certificate
why I submit, enclosed with the petition
Yes,
just to show that she
But
belongs to
if-
BC.
at the time of.
She has a certificate of 2010 because the government of Assam has introduced a new system of providing
Lordship, here
certificate
clearly-
which has to be digitally signed. So this is just a digitally signed certificate. Otherwise also, Lordship, I can place.
No, Lordship, in,
Okay.
it is, he also submit this OBC certificate.
Because in
before the-
2010, the government has already issued a certificate in her favor. This is just a digitally
And
signed certificate.
Closing of the window, Lordship, there are 3 days were there to correct his mistake, Lordship, and he does not do that. And now second recruitment process also started. New notification was issued.
Have you applied?
Lordship, in the second, in fact, on 12th, the review medical, the medical will be held.
Then
He clear, see.
But in that, she realized her mistake. Realizing her mistake, she applied in the OBC category.
This time she cleared the PST, PET, and
Everything.
now everything. Now she is on.
Now you're OBC or unreserved?
OBC, Lordship,
OBC,
OBC,
from
Wait.
Assam,
from Assam,
not from Gujarat.
not from Gujarat. Because she realized her mistake, Lordship.
Then it is all right. You await the outcome.
Yes, Lordship.
Lordship, in that
this-
case, I just place the judgment of the apex court. In the similar fact situation, the Lordship will find at
Now, in all recruitment process,
para number 10. The issue in this repetition involved, and in that particular case, before the apex court are almost identical. And there, the apex court says that the error which is committed by the writ petitioner was not was trivial in nature, and therefore that's not a material error, and that will not affect her candidature and allow the candidature of the petitioner.
Now, assuming we allow your writ petition, what is the benefit you'll get?
She will be medically examined, and she will
Or only for her?
only for her, because the recruitment process is still going on in view of the.
Recruitment for us,
no, all
for
this-
the subsequent recruitment.
No, because this is 2024, wherein your lordship has fixed or has heard repetitions in review medical examinations and directing the respondents. That process is also going on, lordship. This is 2024
No, no,
recruitment.
no. This is a recruitment of what? 21, I think.
24.
24.
24, lordship.
No.
24 recruitment.
This is separate recruitment process. It is a notification advertisement was issued on 23, Lordship.
No, 23 the notification was issued,
Yes,
but the
after that,
recruitment process started in 2020.
recruitment process now going on, Lordship.
Wherein your lordship has already heard. batch
You
of
give her a
repetitions.
copy, let her examine
That-
the judgment.
Yes, Lordship.
You examine it. We'll come back in the second half.
Lordship.
Have you seen the order?
And I have received this just now, Lordship. He gave me. Therefore, I have gone through it.
You want to go through? All right, go through it. When can you come back?
Today, Lordship.
Not today. Day after tomorrow?
Lordship.
Let's this matter again, day after.
Lordship.
Alright.
Lordship, there is an interim order
Request made by
passed by
the
this honorable court.
counsel for the respondent. There is an
Interim order.
Interim
order passed earlier, we'll continue.
vacancy.
Lordship.
May I please announce? The petitioner before your lordship is a constable in CIS. Now he is posted like in oil Doliadan in the district of Dibrugarh. Madam. Pursuant to a departmental proceeding, a petitioner is imposed with a fine of reduction of 7 days pay. Madam.
You will file an appeal?
Yes, my lord, and that punishment is upheld by the appellate forum and as usual, my lord, revisional forum.
Then this matter will require hearing. We'll have to call. You're challenging the proceedings.
No, my lord.
What?
Yes, my lord, proceeding as well as my lord, penalty, my lord, impugn orders,
So we'll have to examine it.
my lord.
Otherwise, there is no loopholes in the proceeding.
Examine it. Heard counsel for parties. Issue rule. All for records. List again. In January?
My lord.
My lord.
January. 20. 20
August.
January. Mr.
K.K. Parasar.
P.K. Parasar, let us see receipt for the respondent. Here.
Published.
Councilor Namdev. Yes, Mr. Chanda.
My lord, that case, your lordship, that Peritine penalty.
Parity in penalty.
Your lordship wanted that.
We have heard, we'll pass orders. We'll pass orders.
My lord, two judgment, your lordship asked me to find out any other judgment.
All right.
Madras bench and Telangana High Court also followed the two judgments I have find out, my lord. From Madras High Court, similar our coordinate bench,
Ah.
two more judgment.
No, no. Here you are relying on the order passed by the coordinate bench.
Coordinate
On
bench,
the ground that the proceedings are similar
yes.
and similar conclusions were arrived at.
Arrived.
That was interfered with, and therefore you are now praying for parity of
Penalty.
punishment
My
on the
quantum of punishment.
quantum of punishment.
Everyone is retained. All others are given only, my lord, two increments
And
down,
also praying for parity of orders
Parity
passed by
of-
the court.
my lord. Oh, everyone is retained.
All right.
And same charge, my lord, same charge in the, and same, only difference of this was observed by the learned single judge, your lordship.
All right.
And two more judgment, my lord, should I?
Yes, give it to us.
My lord, I am relying on two different judgment, my lord.
Hearing is not complete. I thought it was complete. No,
Hearing are almost complete, my lord.
almost.
The record is there. I have gone through the records, my lord. I think he appeal is rejected. And other case is.
What do you say regarding the order passed by the coordinate bench?
That is there, my lord.
No.
That is not
Is
interpret the
is
department.
it
of
a case, is it a case that in the coordinate bench order passed by this court, the facts in respect of that case are completely different? It is the same allegation, similarly situated persons. So,
Allegation is same, but the role of the parties are different, my lord. He is a key person. He is the only computer operator. He is the main person, and other persons are engaged, interested to assist him, my lord.
This is the wrong statement, my lord.
That way, my lord, I am giving, my lord, two cases, my lord. One case is he
He is the
confessed it,
junior most, he is a constable.
and they have confessed it, my lord.
He is
They
a constable,
You will submit.
he is a constable, and H.S. Bhattacharya, he was not given any punishment. SBI Achut Kolita, he is a, my lord, more than Havildar, and it's a same charge, and that was observed by the same charge sheet, my lord. In the judgment itself, the charges were quoted, and the, my lord, findings of the authority is also recorded, my lord. And these are the judgment, my lord. And he is a constable, your lordship.
give it to us. Then we'll carry it again on 11th November.
Yes.
11 November. You give the judgments. You give the judgments. If there is any query, we'll put it across on 11th.
One that I have highlighted, should I give the highlighted copy?
Yes, yes. It is easier for us. Give us the highlighted copies. We love to have highlighted copies.
Can it be on,
Please.
my lord, with your lordship convenience? Can it be on 17th, my lord?
17th.
17th.
17th is a miscellaneous day. We can try on 18th.
19th, my lord, my other cases are.
No, 18th.
18th also, I have got some difficulty. 19th or 17th, my.
19th, what is the?
We can keep it on 19, but we don't know how long it will take.
It is not a hearing.
Then, my lord, to 20.
All right, 20.
Reply of last year.
List again on 20. on the
Lordship,
request.
he is
Joint request by
he is the constable, your lordship. Others are holding the higher post, and Achut Kolita is the main man, my lord.
1 minute. This Narendra Nath, who is respondents have given.
Yes, yes, my lord.
All right.
Narendranath Bhalla and my lord, airport authorities, I am submitting it. Two cases.
Narendra Nath and Airport Authority.
Airport authority only for the confession, my lord. Confession can be taken into consideration in the departmental proceeding. And in Narendra Bhalla, my lord, paragraph 6, my lord, I have mentioned in paragraph 6 A mere repayment of money does not absolve him from the serious charge of this application.
No, this is right, but his ground is on parity.
That is parity, my lord, but I am adding these two cases, my lord.
My lord, only one thing I'll show, only one thing. Confession, your lordship, my friend is saying confession, lordship will find a joint representation. Lordship will find a joint representation. Page 117.
Oh, that is the application,
No,
joint application.
no, everyone.
But in the before the
lordship will
inquiry
find-
officer, he confessed it.
o-
Record says, my lord.
4 persons signed the same representation. Lordship will find page 117 and 118. Rasaraj Bhattacharya, Suresh Roy, Achyut Kalita, Bijit Roy. Same appeal made. All are exonerated. Except this petitioner. Out of 8 persons, all are given minor penalties and 2 persons were given compulsory retirement. And 4, my lord, this in this appeal, 117, your lordship, page annexure 20, 4 persons have signed. 4 persons have signed. And the contention of the EA, same, my lord, facts is EA. Except this, my lord, entire scenario has been placed before thee. And your lordship, other than the petitioner, all are retained in service. Except 2, they were given penalty of compulsory retirement. All are retained. Achyut Kalita, who is the mastermind, my lord, and Bhattacharya was not imposed any penalty.
Okay,
On 20th, my lord.
20th.
Obliged.
For further hearing. On 20th. Item
Obliged.
14. Oh. Oh. Yes.
Your Lordship, the present case as such relates to downgrading of the APR, ACR. Nowadays it's called APR, Annual Performance Assessment Report.
This is what? Central government.
Central government.
Where is your counterpart?
He was here, Ms. B. Sharma, PGC. All right. Otherwise, the law is settled with regards to the Devdutt judgment and after the Abhijit goes to
We had passed certain orders like this, similar orders.
Yes, Your Lordship. I have those judgments. One which was actually very much similar to this present case, in which I only appeared on behalf of the petitioner, and in a similar judgment passed by the Honorable Justice Nelson Silo, and as well as Honorable Justice B.K. Sharma as he then was, as well as.
No, we had, this court had passed several orders in this regard.
Your Lordship, I have to go through them.
No.
Lordship may take it up.
On the basis of Devdutt.
Yes.
4th of December. It's taken on 4th of December, enabling the learned counsel for the petitioner to apprise the court the judgments referred to in the later book in support of his arguments. So, yes.
Items recent dialogue, book number 15.
Yes.
Wait, please, Your Lordship. Lordship, in this case, both the petitioners were employees of State Bank of India, and they were suspended on, my lord, 9/5/2025. My lord, if is referring to case number 5226 of 2025, then page 161, my lord.
1 minute. The notification from silent. Right, so just, let me just confirm with the notification. This is for listing of matters.
Yes, madam. So my
This
lord,
matter is already listed.
no, it was listed there and it was said in a notification if urgent matters are, if any to be mentioned.
No, it's for listing of urgent matters.
Yes.
Only for listing.
So my lord, then please me list on 6th, my lord.
It looks silable again, mention about it. This matter was listed, isn't?
Yes, it was
Before
listed.
that court.
Yes.
So this is not included. It's only for listing matters which are not listed pertaining to that code.
My lord, the person has already 90 days period is over and they have
No,
not.
it will get passed over. They are only deferred. You make a mention before the court.
Yes, my lord may then fix it on 6th, my lord.
We are not fixing it. It will be just passed over. You make a mention before the court. Day after, then get it listed.
I understand, my lord. Because my lord, otherwise, my lord,
There was some, it was not correctly interpreted.
Yes,
It is only for listing of urgent matters.
yes, my lord, listing of urgent matters which are in the deferred list, I believe, my lord.
No, you have a look. এইটো clarification সুধকচোন কি আছে এইটো কি বুজাইছে সিহঁতে
Because, my lord, being a senior bench, so all the mentioning anyway would be have to be done here only.
Only for mentioning. All right. Heard learned counsel for the parties. This matter was listed today. In which court?
My lord, court number 15.
Just court number 15. Stop. However, since this court was not available, the matters were deferred. Stop. Learned counsel, the petitioner has pointed to the notice dated 4/11/2025, where at serial number 3, the registry has permitted listing of urgent matters pertaining to the deferred matters listed before the single bench of Honorable Justice Sardar Ate was permitted to be made before this bench. Stop. As prayed for by the counsel for the petitioner, let this matter be listed again on 6th.
My lord.
6th of November.
I then let them get the instruction. Oh, that cannot be observed.
The respondents will endeavor to complete their